Hey everyone, my name is Dylan. I am MLR's new development coordinator. Minnesota Lakes and Rivers has been around for 30 years now, and we focus on science, education, political advocacy on behalf of lakes and rivers, a lot of legislation that has to do with aquatic invasive species, funding research in those areas, and then we also have education side that really focuses on programs. Lake Steward is one of them. That one focuses on natural shorelines and working with private property owners to restore their shores. Done a lot of webinars on cabin planning in the past. It usually is a pretty popular topic. I think that's where I will hand it off to Jordy, who is our cabin planning expert.
My name is Jordy Griffiths. I go by Jordy, even though my full name is George Byron Griffiths. So I have my own law firm here in Minneapolis called George Byron Griffiths Law. And I am a trusted estate attorney. So about 50% of my practice is estate planning, which does include cabin succession planning, which we're going to talk about tonight. Because I too am a cabin owner in Minnesota. So this is very important to me and very important to my clients, for those who have lake places. So about 50% of my practice is estate planning, including cabin succession planning. The other half of my practice is probate and estate and trust administration. So it's going through the process after someone has passed away to administer the estate of a deceased person. So I kind of work on the front end, getting all the documents done and put in place. But then I also work on the other side after the person has passed away, to go through the process, whether they had these documents in order or not. So it's just kind of all encompassing for that. Okay, all right. So again, tonight's presentation is called Cabin Estate Planning and Cabin Succession Planning. Again, I'm an attorney in Minneapolis, but I am a cabin owner. So this is all very much part of what I'm interested in. Just a little disclaimer, tonight is just for education purposes only. So nothing I say tonight can you take as legal advice upon which to rely. This is just for educational purposes only. If you do have specific questions about your own situation, can't address that in tonight's format, but I am going to pause occasionally and allow people to use that Q&A chat link if you do have a general question about something I am presenting. All right, but let's just go ahead and jump into it. Before we talk about estate planning and cabin planning, we have to take a step back first and really examine the different ways that we own assets. Because based on what type of category of asset you own, it will pass in a completely different manner upon death. So we have three main categories that we talk about. We have joint assets, we have non-probate assets, and then we own probate assets. So I want to go through each of these one by one. First is a category of assets called joint asset. Joint assets are things like joint bank accounts. So in my practice, most often what I see is a married couple. They have a joint checking account and they have a joint savings account. I know that because both of their names appear on the checks, both of their names appear on the bank statement. What happens when one of those owners dies, that bank account passes outright to the surviving joint tenant or joint owner. So when one spouse passes away, it's as simple as the surviving spouse going into Wells Fargo Bank with their spouse's death certificate, and that checking and savings account gets retitled in that surviving spouse's name. So it has nothing to do with what your will says, or if you even have a will or not. It doesn't have anything to do with the probate, which I am going to talk a lot about probate tonight. But based on the fact that it's a joint asset, that's how it operates. Joint assets also include jointly owned real property, real estate, where, again, if I'm looking at a deed with a married couple, it says spouse one and spouse two as joint tenant. In Minnesota, we have to have these three magic words, as joint tenants, actually appear on the deed itself in order for that to be considered a joint asset. If so, and one of the spouses passes away, that piece of property, the real estate, passes outright to the surviving joint tenant. Okay? Again, it has nothing to do with your will, has nothing to do with probate. If it's a joint asset, because your names appear on the deed and it says as joint tenants, it passes outright. And how do you do that? Basically, the deceased spouse's death certificate and another piece of legal paper will get filed with the county. Once those two documents are filed, then that piece of property is effectively in the name of the surviving spouse or the surviving owner. It's not always married couples. Maybe we've got three siblings and they own a piece of property as joint tenants. Well, when one of those siblings passes away, the other two siblings assume ownership automatically by filing that paperwork. All right, so that's how joint accounts work. or joint assets, excuse me, joint assets. The next category of assets that we own are the non-probate assets. Non-probate assets include things like life insurance policies, pension plans, if you have a job that actually provides a pension, both traditional and Roth IRAs, your 401ks, basically any investment account or brokerage account you may have. It also includes bank accounts that maybe are in your own name, but you've got a POD on them, a pay on death debt. This entire category of assets, non-probate assets, pass outright upon death through the beneficiary designations that you list on them, both primary and contingent. So again, what I see most often with the 401ks, and again, I'll use married couples as an example, they list their spouse as the primary beneficiary of their 401k, and they list the 3 kids as the equal contingent beneficiaries. By doing that, again, it has nothing to do with your will. Has nothing to do with probate, because those assets will pass simply by filing the death certificate, and then whoever the broker is, Merrill Lynch or whoever it might be, they will make sure that the 401k gets passed to the beneficiaries. But that's the thing to remember about non-probate assets. You must list your beneficiary designations on them in order for this type of transfer to happen at death. Finally, we have the probate category. Probate assets include the assets that are titled only in your own name. So whether it's your house or your cabin, whether it's the title to your car, if it's in your own name and not joint with someone else, then it is your probate asset. Probate assets also include items without a title or a deed of ownership. So this is all your stuff. This is the boat lift at the cabin. These are all your tools at the cabin. These are your pieces of jewelry, your artwork, your furnish, your household furnishing. Those are all probate assets. And it's only this category that passes through your will. All right. So for purposes of estate planning, your will only dictates where this category, the probate assets, are going to go. Now, when I say that probate assets pass through your will, I put in parentheses here, which may or may not need to be probated. So even if you have a will, sometimes the probate process has to be done after death. And there's 2 triggers for that. Number 1, do you own real estate in your own name? If so, there must be a probate of your estate upon death in order to transfer title. There's lots of ways to avoid probate with real estate, and I am going to talk about it in this presentation. But just all things considered, if you own any piece of property in your own name on the deed, there will be a probate when you pass. If real estate isn't part of the mix, but the second test is the value of all your stuff, all of your things, all of your probate assets, not including real estate, but if everything else exceeds $75,000, then in Minnesota, there must be a probate in order to collect and transfer those assets. So that's the general overview of how we own assets in 3 different categories, either joint, non-probate, or probate. So now let's talk about what are the components of an estate plan. And again, we're not getting to the cabin succession yet, but we start with this components of an estate plan. Every estate plan includes a will. It might include a revocable trust, which is why I've put it in parentheses. I'm going to talk about the pros and cons of having a revocable trust. So not every client needs one, but I put it here because some do. So that's why it's in parentheses. Every estate plan will have a power of attorney document. It will have a healthcare directive. It will have a digital asset authorization, which I'll discuss in more detail. And in parentheses, I also put real estate deeds, because producing new real estate deeds may also be part of the ultimate estate plan that I draft for clients. And we're going to go through these one by one. All right, so what is the will? The will is a legal document that names the beneficiaries of your estate. It dictates where your probate assets go upon your death. Remember, not the joint, not the non-probate, just probate assets. The will appoints the executor of your estate, the person who's going to do the job of administering everything. People are familiar with the word executor, I think, but in Minnesota law, we use the word or the personal representative. That's what they're called under the terms of the will in Minnesota. They're called a personal representative. The will allows you to appoint guardians for your minor children. should something happen to you. It provides for charitable giving, if that's one of your goals. And it includes this thing called a tangible personal property list. So every provision in a will has every will has a provision that deals with tangible personal property. That's your stuff. The article allows for a separate writing, this tangible personal property memorandum, to be drafted, where you can gift certain items, certain things to certain people. So it doesn't actually go in your will. It goes on this list, this tangible personal property memorandum that's incorporated by reference into your will. And that's where you list out who gets what of your things. The wonderful part about that is if you ever change your mind on who gets what, you don't have to redo your will. You just destroy that original tangible personal property memorandum and you make a brand new one from scratch and sign it and date it. It's that simple. So what are the advantages and disadvantages? Well, just having a basic will is pretty easy to establish. It's very straightforward, especially for those who have a very simple estate. You can change this during your lifetime. This is not set in stone forever. In my practice, when my clients hire me and we sit down and we sign all the final documents, I put an alert in my calendar and I follow up with my clients every 3 years. And I provide a complimentary estate planning checkup where I remind them, okay, it's been 3 years since we put this together. Here's how the summary of your plan looks. Here's who we've named in all these roles. Has anything changed we need to talk about? And life changes. So sometimes these documents get changed, and that can be done. But the main advantage is that you provide certainty for yourself, knowing who your beneficiaries are going to be under your will. Okay. Are there disadvantages? Well, there's maybe. Sometimes it requires a probate administration, like I told you. If you own real estate in your own name, you haven't done anything else to treat it differently, which again, I will talk about in a little bit. But all things considered, you'll have to have a probate, and that costs time and money. You also have some loss of privacy when we have to go through probate, because all those documents in a probate file, court file, are public. That means when your will gets probated, that's a public court record and anybody can see what you wrote in your will. But it's important just to remember, if you don't have a will, the state of Minnesota decides what happens to your assets. So if you don't have a will, there are laws on our books that say who gets priority to be a beneficiary of your estate. So let me explain this a little bit more. If you don't have a will and you pass away in Minnesota, you do have a spouse, your spouse inherits 100%. But again, you have to go through probate in the court to get that to happen. In Minnesota, if you die without a will and you don't have a spouse, but you do have children, then your children will be the beneficiaries of your estate according to the law. But again, you have to go through probate to make it happen. If you don't have a spouse and you don't have children, but you have parents that are living, then they inherit from you. If you don't have parents living, then your brothers and sisters do. And that's usually where people stop me. And they say, no, I don't like that idea. So if you don't have a will, the state decides where your assets are going to go. But more importantly, the court decides also where your minor children will go, who will be the guardians. So now, revocable trust. Let's talk about this. Sometimes instead of just a basic will, I draft a will plus revocable trust plan for clients. So you still start with a will, and basically the terms of the will say, upon my death, I devise everything to my revocable trust. And then this revocable trust document takes over, and it's the legal document that names the beneficiaries of your estate, where these probate assets were going to go. Okay, so the terms of the revocable trust list who all your beneficiaries are and how you're leaving your estate when you die. This document appoints a trustee of your estate, and it also allows for you to do the charitable giving and have the tangible personal property list, just like you did under the will. So why would you do a will plus a trust plan instead of just a will plan? Well, the main advantage of having a trust is to avoid the cost to probate your estate. So when you have a will plus a trust plan, you don't have to go through probate. That's why people put trusts together. It is a probate avoidance mechanism. And because of that, you get to maintain privacy of your assets and your family matters, because that trust is never part of a court record. That's a private document. So avoiding probate and maintaining privacy, these are the two biggest reasons that you want a trust in addition to your will. And again, you can modify the trust during your lifetime. That's why it's called a revocable trust. It allows you to amend it or change it or completely revoke it if you don't want it anymore. One of the wonderful provisions in a revocable trust is that it helps provide management of your assets, your trust assets, if you become incapacitated. The language is built into the document. Nobody has to go to court to get a judge to say, okay, now someone else is in charge of your trust because you're incapacitated and can't be your own trustee. It's automatic. That's a huge advantage of having a trust. And also the trust helps you plan around potential estate taxes. Now, at the federal level, everyone is subject to a federal estate tax when you die, but we all get an exemption or an allowance, I would like to call it. But currently at the federal level, that exemption amount is $15 million, almost $15 million per person. That means a married couple can pass 30 million down to the kids at a federal level without there being federal estate tax. Minnesota is one of a handful of states that also has a state estate tax. And currently in Minnesota, our exemption amount is $3 million per person. That means a married couple can pass a total of $6 million to the kids without there being any estate tax owed. And anything in addition to that $6 million then is taxed at a rate of, I think it's 13%. But having a trust is going to have specific language in it that allows you to make use of both of those spouses' exemptions. So that's why it's important if you think that you're going to be dealing with that threshold. So, well, what are the I mean, this sounds all great, right? Well, what are the disadvantages? It is more expensive to establish than just a basic will. I'll be quite honest. As an attorney, it is much more work for me to do a will and trust plan than it is a basic will plan. So it's more expensive to set up at the outset. And also, creditor claims are not cut off. What I mean by that is just because you retitle your brokerage account and your checking account in the name of your trust, it doesn't mean that you don't have to pay your credit card debt off when you die. You can't shelter assets in that manner with a revocable trust. So those creditor claims are not cut off just because you've established a trust and have put these assets in the trust. Okay, before I go on to the next component of the estate plan, I'm going to pause for a second. Any basic questions on that?
I have a few in question, Wade. How is an irrevocable trust different?
Yes. An irrevocable trust is different because basically when you set up an irrevocable trust, you lose the ability to modify it in the future or to change it. People put together irrevocable trusts usually when they have an estate that's over $6 million. And they want to figure out, how do I shelter the excess that I have over 6 million? Well, you put it into an irrevocable trust because then it takes it out of your estate for calculating the value of your estate upon death. But it means whatever you put in that revocable trust, you can't control it anymore. You give up control completely. So that's the difference between a revocable, where you can continue to control it, and it is part of your estate, and an irrevocable trust where you lose control, but it's no longer part of your estate.
When one spouse passes and we have a will and all assets are inherited by the surviving spouse, does that become a single owner? And if so, is that probatable?
Well, remember, we only go through probate if the spouse who died owned real estate in their own name, or if the value of all of their personal property exceeds $75,000. But usually when we're dealing with a married couple, even that doesn't really come into play. You know, most married couples own a majority of their assets in the joint and the non-probate category, so they co-own the house together and they list each other as the beneficiary designation on the non-probate. So usually there's no probate when the first spouse passes away, but it's when the second spouse passes away and everything got retitled into just their name, that then you have a probate. A lot of times I have clients who want to just do the basic wills, and then after the first spouse dies, then the surviving spouse will redo their estate plan, and they will set up a will plus trust plan so that there will be no probate when they die based on the fact they're the sole owner on all of these different assets.
Who should be identified as a trustee?
Well, that's a great question. Again, let me start with the example of the married couple. Usually, so when I set up a will plus a trust plan for married couples, at the outset, I establish their trusts such that both spouses are trustees of each other's trusts. So spouse A has a trust, spouse A and spouse B are going to be the trustees of that trust. Same thing, spouse B on their trust, both themselves, spouse B and spouse A will be trustees. And then usually after both spouses are gone, the successor trustees are usually the kids, the adult kids, and maybe they'll put one or more kid to act together. Maybe they'll put them in succession. But I will say this, I also have clients that don't have children and maybe aren't even married. So who do they pick as a trustee or as a personal representative under the will? And the answer is you can pick anybody you want to. So sometimes people choose their best friend from college or their next door neighbor who they trust. Or they might name a sibling. Some people don't want to put that burden on anybody they know. So another option of a personal representative and a successor trustee is actually a professional fiduciary. So I have a list that I maintain of about 6 different companies in the metro area of Minneapolis who provide that service. They allow themselves to be named in your document, and that's what they do professionally. They administer estates after people die. And of course, I mean, they do charge a fee, but it's a way of not having somebody you know have that burden when you don't want them to. I often use a professional fiduciary as a trustee when there's a situation where one of mom and dad's kids has a substance abuse problem. And while they want to leave the kid an inheritance, they don't want them to get a windfall of money. And they don't want the brothers and sisters or an aunt and uncle to be controlling when they get payouts. So that's when we appoint a professional fiduciary to act as trustee. Okay, I hope that helps. Anything more?
Oh, that's awesome. We can keep going.
Okay. The next component of your estate plan is a power of attorney document. So what is this? A power of attorney is the legal document that appoints someone else to make your legal and financial decisions for you. And that's during lifetime, while you're alive. The power of attorney document becomes null and void upon your death. Now, if you don't have a power of attorney, maybe you're going to end up with conservatorship proceedings in court. So let's say that you're an unmarried person. You have your checking account in your own name, but you get into a car accident and you're in a coma and there are bills that are not on auto pay and somebody's got to write checks to pay your bills. Who's going to do that? Well, we got to look to your power of attorney document to see who you appointed to be your attorney in fact. That's the person you're granting the power to write the checks out of your checkbook. If you are in a car accident and you're in a coma, you don't have this power of attorney document, somebody's going to have to initiate conservatorship proceedings for a judge to decide who should have the power to write checks out of your account. So the power of attorney is the document where you're appointing an attorney in fact to act on your behalf. You can name one person, you can name 2 or more attorney in facts, and if you have 2 or more acting at the same time, you can require that you can say they can either act independently or you require that they must act together, joint. So again, let me use the example of the married couple. Spouse usually lists the other spouse as their primary attorney in fact, and then they name the 3 kids as the alternates. And maybe they list the kids separately in order, 1, 2, 3 in succession, or maybe they list all 3 kids together as the alternates. And you know what? All 3 have the ability to act independently if they need to. The important thing is that when you do a power of attorney document, the person or people you're appointing as your attorney in fact must be trustworthy, because as soon as you're signing this, they have immediate power. Okay, but that's why, again, mostly it's married couples where they already have joint bank accounts. But you still have to have, a situation that's covered where you don't have a joint asset. That's when you would use the power of attorney form. The next component of your estate plan is your healthcare directive. This is a legal document that appoints someone else to make your medical decisions for you, only if you can't communicate your wishes and intentions to your doctor. That's the only time this document comes into play, when you are alive and you cannot communicate what you want to have happen for your healthcare. And again, this becomes null and void when you at death. But if you don't have this in place, there might be possible guardianship proceedings in court if there's a dispute. I'm probably aging myself, but maybe some of you remember hearing about the Terry Schiavo case. That was a woman who ended up in a permanent vegetative state. I don't remember if it was after a car accident or a surgery or something, but basically the doctor said there's no hope of survival, permanent vegetative state. Her husband wanted to end life support, but her parents didn't want that to happen. Terry Schiavo did not have a healthcare directive. She did not have a legal document that appointed her husband to be the healthcare agent. And just because you are married, your spouse does not have the automatic legal right. If there is a dispute between, like there was, between her husband and her parents, but there's not a legal document that says who the doctor should listen to, then you are going to have guardianship proceedings. And that's what happened in that case. It was a long, drawn out battle. And I think finally the husband was awarded that power from the judge, from the court. But it was brutal, the process that they had to go through. So the healthcare directive is the name of the document where you are appointing a healthcare agent. The agent makes your medical decisions when you can't communicate with your doctor. This document also lets you indicate if you want to be buried or cremated after death. And it can also say whether or not you want to be an organ donor. So again, mostly I've got married couples naming their spouse as their healthcare agent, with the kids usually in maybe a different order than they put on the power of attorney document, because the skill sets necessary in this role, being a healthcare agent, sometimes are very, very different. And my clients know, hey, one kid's really good with finances, but they'd be horrible at this medical decision. And the other kid would be better at that. The most important thing is that you just talk to all your agents about what your wishes are. So nobody's left in the dark wondering what you may or may not have wanted to have happen. So number one, get the document in place. Number two, tell your agents what you want, or maybe more importantly, don't want to have happen. The next component of your estate plan is your digital asset authorization. So what the heck are digital assets? You're probably asking yourself. The best example I can give you are your Sky Miles with Delta Airlines. If you try to call up Delta Airlines and ask them to send you your frequent flyer miles in the mail, they will laugh at you, because those do not exist on any kind of piece of paper. They are numbers in an online account. But for some people, that has tremendous value. I use myself as an example all the time, because I think it's important for clients to have real world examples. My father traveled a lot for business. My mother died before he did. And after my dad died, when my sister and I were the successor trustee of Dad's trust, one of the things we had to do was contact the travel companies, the airlines. And between Delta, American, and United, my dad had over 1 million frequent flyer miles. And we were able to collect those and transfer the miles into our accounts because my dad had a digital asset authorization. That's the piece of paper that Delta needs to be able to follow the instruction of the successor trustee who's telling them where to move those miles into. So it includes the frequent flyer miles. It includes all of your World Perks credit card points. It includes all of your online accounts, all of your online presences. Facebook is a little different. Facebook, Mark Zuckerberg has decided that Facebook does not have to recognize the federal law around digital assets. So on your Facebook account, you actually have to go in your own account and establish what's called a legacy contact, where you say who is the person you're giving authority to take over your Facebook account after you die. So unfortunately, the digital asset authorization doesn't work for Facebook. It also does not work for Bitcoin. If you have cryptocurrency, specifically Bitcoin, you must have that keychain that goes along with your Bitcoin, because Bitcoin will not accept a digital asset authorization. Okay. So that said, how are you going to help your fiduciary, your personal representative in the will or the trustee under your trust? You're going to start keeping track of your digital assets on an inventory list. And that's something that I provide to my clients at the end of the estate planning process. That thing is going to include your usernames, and you can put down your passwords if you want to, but in the absence of your trustee knowing what your password is, they use that digital asset authorization form that you signed. along with your estate planning documents. And then it's just important to tell your personal representative or the trustee where you've put that inventory so they know what kind of list do I have to go through after you've died? What kind of accounts do I need to go online for and start shutting down? When I said that part of my practice is probate and estate administration, which deals with after people die, I often tell the story that it used to be much easier to do the job of settling someone's estate years ago before the computer, because you simply went into their home office, opened up their file cabinet, and there they have all their bank statements and all their titles and everything else. You know, who of us gets paper bank statements anymore? We do everything online. So we have to keep track of what all of our online accounts are and usernames, especially, so that our personal representative and successor trustee knows what kind of job they've got to do for you after death. All right. Sometimes estate plans include real estate deeds. So I'm going to talk about the two that I use most often in general terms. The first is a quitclaim deed, and I use them to ensure joint tenancy on a piece of property. So I talked about joint assets and how that includes real estate where, again, let's say we have two spouses and it says as joint tenants on the deed. Every time I meet with new estate planning clients, I always pull the deeds for any piece of property that they own to see if those three magic words as joint tenants are on there. 9 times out of 10, they are, but 1 time out of 10, continually in my practice, somebody made a mistake and they just put spouse 1 and spouse 2 and they left off the words as joint tenants. So to change that, I draft a quitclaim deed that says we, spouse 1 and spouse 2, the owners of this property, we hereby convey and quitclaim to ourselves, spouse 1 and spouse 2, as joint tenants. And then we record the deed with that county, and now we know it's a joint asset. Because the default in Minnesota, if the deed does not have those words as joint tenants on it, the spouses own it as tenants in common. That term means they each own the property 1/2, and it's their probate asset, which means that when one spouse dies, their 1/2 share has to go through probate. So I do the quitclaim deed, number 1, to ensure that we own property as joint tenants, if that's what we wanted. But then I use quitclaim deeds to put the real estate into a trust to avoid probate. So when I do a will and trust plan for clients, it's not enough just to draft the trust and have them sign it. With real estate, we actually have to retitle the property in the name of the trust in order to get that probate avoidance. I have a lot of clients who have, let's say I have a lot of clients that say, you know, they have a house in Minnesota, but they have a cabin in Wisconsin, let's say. Those type of clients, I definitely push to do the will and trust plan. And a lot of times what I would do is to put the deed for the Minnesota property in spouse 1's trust and the deed for the cabin property in spouse 2's trust. That way we're avoiding probate in both Minnesota and Wisconsin. Because if a married couple simply just owned the house in Minnesota and the cabin in Wisconsin as joint tenants, well, that's great, but only if it's just one spouse that dies. What if they die at the same time? If they were to die at the same time and you don't have a trust and you didn't retitle the property in the names of the trust, guess what? Yes, you guessed it. Probate in Minnesota and Wisconsin. So that's how we avoid probate. With real estate, we've got to do a deed to the trust. Another deed I draft very often is called a transfer on death deed, which is exactly what it sounds like. It's a deed that says, upon my death, I hereby devise this piece of property to ... So if I have clients that say, oh, you know what, we don't want to go through the cost of doing the revocable trust and it just seems complicated to us, can't we just do a transfer on death deed and put the 3 kids on it? The answer from a legal standpoint is yes, but I refuse to draft that. And here's why. On a transfer on death deed, if it says we, spouse 1 and spouse 2, the owners of this real estate with this legal description, upon our deaths, we hereby devise, upon the deaths of both of us, we devise this property to our 3 children as joint tenants. All right, mom and dad both die. Now you've got 3 siblings and they decide they're going to sell the house. Well, with a transfer on death deed, because all 3 siblings are now entitled, all 3 of them have to agree on that sale price. And in Minnesota, guess what? If any of those children are married, their spouses must provide consent. That means you potentially have 6 people in the mix trying to sell mom and dad's house. That's a disaster, and I won't draft it. I only use transfer on death deeds to avoid probate for one child. So if you got 3 kids, I'm not doing a transfer on death deed. I will only do the transfer on death deed route if you've got one child who maybe hopefully is not married. But it's a great way to avoid probate when there is only one child. You don't have to go through the more complicated trust route. Transfer on death deeds are easy to draft, they're inexpensive to file, and it's only effective upon death. So it gets drafted, it gets recorded with the county, but the transfer on death deed then just kind of sleeps there. It does not go into effect until the death certificates are filed with the county. So it doesn't stop your ability to be able to sell the property or refinance it if you want to. All right. Before we talk about probate, now we already talked about the will and the trust. Now I've talked about the power of attorney, the health care directive, the digital asset authorization, and real estate deeds. Any general questions on those 4 components of the estate plan before I move on?
Is there a different process with tenant and common rather than joint owners? Thinking along the lines of if you own, you're like 4 cousins who own a fourth of the property.
Yep. So that's one of the reasons why I always go to the county directly and pull the current deed to examine it so that we know exactly what we have. So yeah, let's say some property passed through the family, whether it's a farm or the cabin. Who's currently entitled on the cabin and how? If you've got 4 cousins or maybe 4 siblings, let's say, mom and dad deeded the property to all 4 kids. And then if the words as joint tenants is on there, and again, let's assume it's a cabin, one of the siblings dies, there's no probate. The other 3 siblings assume that 4th sibling's ownership shares just by filing their death certificate and another piece of paper with the county. That's scenario 1, where it says as joint tenants after the 4 kids' names. Scenario 2, let's say mom and dad deeded the cabin to all 4 kids. They list the 4 kids' names, but that was it. Then it is not a jointly held asset. The default is that they don't own it as joint tenants. They own it as tenants in common, all 4 siblings. Now, one of those siblings dies. So then what happens? Their 1/4 share of the real estate has to go through probate, and it's going to pass according to their estate plan if they had one. It'll pass according to whatever their will said. And if that sibling who died didn't have a will, then the state of Minnesota is going to dictate where their 1/4 ownership of the cabin goes. Okay, that's the difference between joint tenants and tenants in common.
Can you revise the TODD?
Yes. Yep. The transfer on death deed can be changed. Yes. According to Minnesota law, the most recent transfer on death deed wins. So if you draft and record one transfer on death deed, and then a couple years later you draft a new transfer on death deed and you record it, it's that most recent one that controls. Other questions? All right. So let me talk for a couple more minutes about probate, about what this word is. And I put it in red letters like this because I think somehow probate gets a really bad rap in Minnesota and elsewhere. And I think it does because we've all probably been to cocktail parties or dinner parties, and somebody tells a story of so-and-so's great aunt's estate was wrapped up in probate for years and cost tens of thousands of dollars and lawyers' fees. Oh, probate is terrible. Avoid it at all costs. Sure, those stories absolutely happen. Usually, however, those probate stories are happening when people are fighting over grandma's will. And when people are fighting over the will, then yes, you're going to have probate go on for years and cost thousands of dollars. In Minnesota, if you die without a will, or even if you do have a will and you have to go through probate, excuse me, let me back up. In Minnesota, if you die without a will and you own real estate, yes, you have to go through the probate process. But as long as none of the beneficiaries of your estate are minors, then we can do what's called an informal probate administration, okay? Even if you have a will and you own real estate and you have to go through probate, again, if none of the beneficiaries under the terms of your will that you did get done, as long as none of them are minors and nobody's fighting, we can do this informal probate administration, which simply means that paperwork gets drafted and submitted to the court registrar, and they generate the necessary court paperwork. We don't even see a judge or have a court hearing. It's a pretty streamlined process. It does cost time and money, though. I mean, I'm not going to lie, but it's not always such a terrible thing to have happen, to go through probate, because then you have a court blessing on the fact that, yes, this is a valid will, and yes, this is who the beneficiaries are. So sometimes probate can be a good thing. But just remember, probate is the court supervised process either of authenticating your last will, if the deceased made one, or for the court to determine who the rightful heirs of the estate are if no will was made. It's about locating and determining the value of the decedent's probate asset, only that third category we talked about, those assets that are titled only solely in the person's own name and where they should go. And you can avoid probate, especially when you have real estate, if you put together that revocable trust or you have a transfer on death deed. But now you don't have to worry about probate at all if you don't own real property and your rest of your probate assets are less than 75,000. Those are those two triggers I talked about. We're about to move into the cabin succession planning. This is what everybody's here for. But any other final questions before we move on? All right, let's get into it. So now what do we do with the family cabin? All right, this is a big topic for a lot of us Minnesota people who own lake property or property on a river. What are we going to do with this cabin? And it is part of the total estate planning process. And essentially, there are kind of 4 different ways to think about what to do with the family cabin. We can gift it during lifetime while we're alive. We can gift it at death. We can put it into a cabin trust, its standalone trust, or we can form a cabin LLC and put it in that. Those are kind of the 4 main processes that I go through with clients when we're talking about what to do with the family cabin. Now, before we get into each of these 4 choices, we got some big picture questions to address. And this is how I always start with clients. Number 1, how long do you realistically expect to keep the cabin in the family? You know, yes, this was the cabin that grandma and grandpa built. And then it came to the 4 kids. Well, now the 4 kids each have 4 kids. And what if those grandchildren then each have 4 kids? How long are you really going to keep this going? I understand the sentimental value. Believe me, I do. Because I am a cabin owner that belonged to my parents. The emotion and the sentimentality regarding the sacred space is so vital to all of us. But when we're talking about estate planning and cabin succession planning, you have to step back from that a little bit and start to be practical and really think, how long realistically can we keep this going? Number 2, if or when the cabin is sold, what is that going to look like to you? You know, how are you going to feel about it? Whether it is mom and dad who are selling the cabin now, out from underneath you. Or if you get to a point now and you just realize we can't keep this going anymore, we got to sell it. You got to think about what that's going to look like. This is the big one. How will you or the children continue to pay for the cabin upkeep after the grandparents are gone or after mom and dad are gone? This is what I run into most often. You know, mom and dad have got, they have grandma and grandpa's cabin now, but now they've got 5 kids. And now mom and dad are starting to think about, okay, what's going to happen to the cabin after we die? We've got these 5 kids. Well, one of them lives on the West Coast and they only come for the 4th of July. One of them lives in New York City, and maybe they come twice a year. You know, the other one comes to the cabin every weekend and they are a school teacher and they just don't make much money. But the one who's on the West Coast and the East Coast, they make a ton of money. How are you practically going to continue paying for the cabin moving forward? Who's going to be able to afford it? A lot of times I tell clients the best thing you can do if you're worried about that is to figure out what are the annual carrying costs on this cabin. How much does it cost us to keep it going on an annual basis? Figure out what that number is. And then I say multiply it by 10. And put together a reserve fund for the cabin to keep paying those ongoing costs for at least 10 years after mom and dad are both gone. That way you don't have to worry about which kid can afford it and which one can't. You've paid for it already. And if people can't do that, then we'd have to have other discussions about what cabin succession planning looks like. Here we go. Number 4, what conflicts do you anticipate and how do you expect your children to resolve conflicts? Well, you get to use the cabin every single weekend. I only come once a year. I shouldn't have to pay for, all of the upkeep on the boat because I don't use it. There are so many of those kinds of questions, and you're going to have to anticipate what those issues are and come up with a plan to address it. And then number 5, how are you going to plan to communicate that plan to your children? I often facilitate family meetings where we address these concerns and these issues, and I come in kind of as the neutral to help steer the discussion so that we can stay on task, we can stay practical, but somehow you got to be able to tell the kids what you're going to do and why, and that needs to be talked about. And those are sometimes hard conversations. Okay, those are the big picture. It's not always rosy. And I'm going to be honest with you, sometimes in my practice, cabin succession planning doesn't work because all of these factors together, it's just too overwhelming and it's too much to make it something that actually does work. But thankfully, I also have clients for whom this works perfectly and everything falls into place. There is a mechanism to do it, to help keep it in the family. There is family harmony. There is money to pay for it. And so sometimes this does work really, really well. So how do we think about doing it? Well, you could gift the cabin to your kids during your lifetime. So while you're alive, you can literally gift it to them, give it to them. So what are the benefits? Well, then the children pay the cost of the cabin. The cabin is out of your taxable estate because if you give it away to them, it's no longer, that asset is no longer part of your estate when we calculate the value of your estate upon death. So if you're worried about that $3 to $6 million, the $3 million per person, $6 million total exemption, you can get the cabin out of your estate before you die by giving it to the kids. And sometimes when you do that early transfer of the cabin, you can avoid medical assistance issues in the future. Now, I'm not going to talk a lot about medical assistance in this presentation, but I think everybody understands that if you require nursing home care and you don't have long-term care insurance and you have to go on medical assistance, they look at all your available assets. And they even look at transfers that you have made up to 5 years before you need medical assistance. So if you gift the cabin to the kids and then 2 years later you go into a nursing home, you think, oh, well, a cabin, I gave it away to the kids. That's not part of my assets. Yeah, it is, because we have a 5-year look back period where that can be brought back in and considered an available asset for medical assistance recovery. So other drawbacks are potential cost basis issues. So let's say mom and dad, you bought the cabin 30 years ago for $100,000. And in today's market, that cabin is now worth $1 million. Well, if you gift it to the kids while you're alive, the kids have your cost basis of $100,000. So if you gift it to them and then they decide, oh, we can't really keep this going anymore, we're going to sell the cabin, but now it's worth $1 million. Well, there's going to be capital gains taxes on that additional $900,000 in increase in value. So that's a problem when you gift during lifetime. You have that cost basis problem with highly appreciated real estate like cabins usually are. And you have a lack of control of that property now because you gave it away. So those are the benefits and drawbacks of giving the cabin to the kids while you're alive. But it is one method. Second method is that you just gift it at death. So you keep cabin ownership and you devise it to the kids after your death. Maybe you do a transfer on death deed to one kid. Or you set up a will and a trust plan, and in the trust it says, I leave it to the 3 kids in equal shares, and we retitle the cabin in the name of the trust. All right, that will happen upon death. So you are in control of the cabin, you pay for it while you're alive, but after death, you're giving it away in that manner. The benefit is that there is a step up in the cost basis, okay? So back to that example where mom and dad were going to give the cabin to the kids during life, which they paid $100,000 for. Again, the problem is that if the kids then go to sell it, they've got to pay capital gains on the additional $900,000. When you gift at death, you get a new step up in basis. So if mom and dad do a transfer on death deed that says upon the deaths of both of us, this cabin goes to our one and only child, then upon your deaths, the new cost basis is the fair market value of at the time of death of the second spouse. So that means if, let's say, mom and dad both die together at the same time, transfer on death deed goes into effect, both of their death certificates get filed, and now the one kid is the owner of the cabin. Guess what? Their cost basis is now $1 million. And if they go to sell it the next day for $1,000,005, there's only capital gains on that 5 cents. That's the major advantage of giving at death, is the new step up in basis. Plus, you get to continue to own and control that cabin during your lifetime. None of that goes away until after your death. Okay, so what are the drawbacks of waiting until death to give the cabin away? Well, you are going to pay the cost during your entire lifetime of that cabin upkeep, and that cabin is probably going to be included as part of your taxable estate when we're dealing with potential Minnesota state tax. So those are the main benefits and drawbacks with gifting during life versus gifting at death. Well, what if we set up a cabin trust? So the parents could create a revocable cabin trust, this separate standalone trust entity, and then transfer the cabin into the trust. So I would do a quick claim deed from the parents, the owners, into this new Smith Family Cabin Trust that I create. The parents get to retain the right to use and control that property, and therefore, this is not a transfer of the cabin to the kids. It's basically a gift at death. Well, excuse me. It's transferring to the trust itself. It's not giving it to the kids, it's giving it to the trust. And then the trust document will dictate what happens to this cabin ownership after mom and dad are both gone. Upon the death of the parents, that cabin trust becomes irrevocable. It can't be changed in the future after mom and dad die, the people who created the cabin trust, okay? And it's the cabin trust that retains the ownership of that cabin property. And the terms of the cabin trust say, all right, what happens after mom and dad die? And then you have to have your kind of your whole list of, again, what happens to the ownership? Well, you know, what happens when the 4 kids then die? We have to have all of that spelled out in the terms of the cabin trust. Okay, so the trust is going to dictate how the cabin is to be managed following the death of the parents who set up this cabin trust. And again, we set up the cabin trust to avoid probate based on the ownership of the cabin too. Okay, so the cabin trust avoids probate on the property, and it also provides for the future of this property. What is it going to look like, and how far down the line will ownership be going based on the terms of what the cabin trust says? And that's really hard to flush out sometimes. And again, here's the big hard question. How are we going to fund this trust if these kids don't have the means to afford the upkeep on the trust? Do mom and dad have enough to put, and I always say, at least 10 years of funding into an account to keep that cabin going? Because if the kids can't afford it on their own, at some point, this cabin trust just doesn't work, and the trust has to be terminated and the property sold. Or you could do a cabin LLC, which essentially is kind of the same. It's just instead of creating a trust document, we're creating a business entity, an LLC, the Smith Family Cabin LLC. So the parents could form an entity to hold the cabin property. And again, typically it's LLC that I use, limited liability company. The cool part about the LLC is that parents can start to gift or sell the LLC interest to the kids while they're alive. It doesn't have to wait until death for the kids to start assuming ownership. But remember, if you gift, then there are potential issues of with gift tax returns and a lot of other things. And you really have to talk with a qualified CPA or tax person if you're going to be gifting or selling LLC interests. But, you know, any disputes that go on with how the cabin's going to maintain or what's going to happen, those are business disputes instead of family disputes, kind of, especially if you have outside agencies that you name to be president of the LLC. Although most clients want their kids and grandkids to be named as the officers of the LLC. And of course, there are costs associated with the creation of an LLC entity and the ongoing maintenance of a business. And sometimes people perceive it as being really complex because maybe they're not business owners and they don't understand how LLCs work. For the people who do understand LLCs, this is a great option. So cabin trust versus cabin LLC, honestly, it depends on mom and dad and what they want to do and what entity they're more comfortable having. But essentially, it kind of goes to the same ultimate goal, which is how are we establishing the long-term, the longevity of this cabin for the sake of our family. The big takeaways is that there is no one answer on what to do with this. It's going to be so different from family to family. Every family dynamic is different. Every makeup of family is different. Every history of the cabin is different. There's no one size fits all solution to this. And again, I know that we struggle over the sentimental value versus the practical nature of ownership, especially if we're trying to make it go a few generations down the road. All right. I've gotten to the end of my presentation, so now is the time for questions.
If a cabin or farm property is held in a partnership with outdated documents, what happens if one person dies?
There's really no expiration date, but if for some reason the old documents aren't really clear about how this gets taken care of in the future, and it's ambiguous, it may mean going to court to having a judge interpret it and actually provide the direction that you're uncertain about. No, they don't expire. But again, if something comes up that wasn't anticipated that now we're having to deal with, we might have to get court interpretation.
In a revocable trust, I have 3 children, but I want to transfer the cabin to just 2 of them. Can we also add that if one of them dies, we can pass the cabin to their children, our grandchildren?
Absolutely. I have this happen a lot where, you've got 3 kids, but only 2 of them really want the cabin. So usually what I start doing with that instance is creating an equalization clause in the trust, which says, okay, well, if the trust is worth $1 million and it's going to 2 of the 3 kids, so that's $500,000 for each of those 2 kids who wanted the cabin, I put in an equalization clause so that the 3rd kid who didn't want the cabin will get the equivalent amount, $500,000 worth of other trust assets to make that equal. Because mom and dad want to treat the kids the same, but they know that only 2 of the 3 kids want the cabin. So you make sure that you're going to provide for the other one who doesn't want it. So I start there. And then, yes, these 2 kids who want the cabin, what happens if one of those kids dies the week before both mom and dad do? Yeah, you got to figure out what happens to their share. Sometimes clients just say, well, if that happens, then let the other kid become the sole 100% owner of the cabin. And we know he'll invite his nieces and nephews up to use the cabin. Some say, well, no, if I want to make sure that 1/2 share of that cabin stays in that son's family bloodline. So if the son dies before me, then his 1/2 share of the cabin goes to his 3 kids. We absolutely can draft that. But then we run into all the questions that I posed before. If mom and dad don't leave a 10-year reserve to keep the cabin going for those 2 kids, and one of the kids dies and now their 3 kids take it over, how are they going to afford it? And what's going to happen if one of them die? So yeah, we got to go down the rabbit hole and flush out all of these possible scenarios. But yes, it's absolutely possible to do that. And I do it all the time. Yeah.
Clarification, if you have other properties and you put everything and title it into a trust, so your other house is in the trust, your
Yep.
Sunshine State properties in the trust, and the cabins in the trust, are you saying the cabin trust document is a totally set aside separate thing? Or are you, if you're putting everything in the trust, is that the cabin trust you're talking about? I couldn't tell if it was a separate special thing just for the cabin.
Great question. If I do a will and a trust plan, that takes into account all of the assets. And if I do just a cabin trust, it's just that asset itself. Again, I use myself as an example all the time. I own a condo in Minneapolis. I own a condo or a cabin up north, and I own a place in Palm Springs, California, because that's where I go in the winter.
Mm-hmm.
So for myself, my own estate plan, I have a will and a trust plan. And my condo in Minneapolis, my cabin up north, and my place in California are all titled in the name of my revocable trust. So I don't have a separate standalone cabin trust. because I don't have the complexity of that situation to deal with. So I don't do a separate cabin trust for my cabin. It just falls within my regular estate plan, which is my will and my trust. So when I'm going to start the cabin succession planning conversation with estate planning clients, they first get about a 15-page questionnaire from me that they have to fill out. And it's going to start asking those really pointed questions of, okay, well, if we set up this cabin trust and the pontoon motor conks out, how do you decide what horsepower motor to buy to replace it? And those terms then become part of the cabin trust document, or they become part of the operating agreement of the cabin LLC.
For a trust or LLC, can you restrict spousal rights if your child gets divorced?
Yes, absolutely. I just put together a cabin LLC earlier this year. Grandma and grandpa built the cabin, had 3 adult kids who now all own it as joint tenants. And those 3 adult kids want their kids, the grandkids, to inherit their LLC shares after they die. Okay, so grandma and grandpa gave it to the 3 kids. Now the 3 adult kids hired me to draft a cabin LLC. So they each have 1/3 share of the LLC. And now when one of the adult kids dies, their 1/3 shares go equally to their kids. But when those kids start dying, the shares go away. So this cabin is going to be left to whoever is the last grandkid standing. They become the sole owner of grandma and grandpa's cabin. That's how they wanted it set up. Now, to do that, I drafted a spousal consent that every single one of the spouses had to sign, where they say, I realize that this is a family cabin. I'm not going to get ownership shares of this LLC when my husband dies. They're going to go right to my kids, and I consent to that, and I have to sign it. So that's how you deal with it during life. But the terms of the LLC operating agreement also says there are no spousal rights ever. Like if there is divorce, that spouse never had any rights to begin with because they signed the consent during life that they gave up their rights to the LLC shares. Yep. So answer is yes. It's a little complicated, but it can be done.
Is there a one-time cost to a trust, or are there ongoing costs?
That's a great question. And again, the answer depends. In my practice, I do my estate planning on a flat fee basis. So I charge a flat fee for setting up the will and the trust. Usually I do a flat fee for the cabin trust too, except sometimes I have to modify that depending on how complicated our situation is. And then for me, I don't charge again. I provide, like I said, that free complimentary 3-year checkup every year, and I don't charge for that checkup. I only charge again if they want to make changes to the terms of their trust or make changes to the terms of the cabin trust because they changed their mind. Then I charge again when I have to do new drafting.
If surviving parents has 2 properties and 2 children, is there a drawback to doing one TODD for each child? They're just wondering if there's a drawback to doing that.
So 2 different pieces of real estate. You're going to do a TOD to one kid for one piece of real estate and a TOD to the other kid for that one.
Mm-hmm.
I think the only question I would have is there a big difference in fair market value of those 2 properties? You know, are you going to end up gifting something worth a whole lot more to one kid than the other kid who's only getting that property? And if so, then again, if you do a transfer on death deed, then it doesn't go through probate, doesn't go through the will. You may have to make other types of equalization clauses in your will or your trust if you want to really try to make the dollar values equal. So that's the only question I would have for the client. But in terms of being able to do that, yes, absolutely.
When creditors come for a cabin trust or LLC shares, is there a certain way you go about to keep creditors away?
Well, this gets into something a little deeper. Because I have people say, well, wait, I've heard if you put a cabin into a specific kind of trust, you can keep the nursing home from coming to get it. Well, that's if you set up an irrevocable cabin trust, which then takes it out of your estate, but then you have no control over it again. But it is protected from creditors that way. But who wants to give up their control of their cabin? So I don't do that. From the LLC standpoint, I don't believe the creditors can't come in. The only thing with LLCs that's a little different than the cabin trust is that if you set up an LLC entity and you retitle the cabin in the name of this LLC, one of the additional advantages is that it protects the people from personal liability should somebody fall and slip on the dock at their cabin. You know, they can't go after all of their assets. They can only go after what's in the LLC. So that's more of an insurance strategy, I guess, with the LLC as well. So, but in terms of like, if you set up a cabin LLC, it would still be an available asset for medical assistance, I'm pretty sure.
How difficult is it to do a trust or LLC if the cabin is jointly owned with other family members?
It depends on the family dynamics of those family members. Because like I said, when I just did this one where everybody agreed, hey, cabin ownership is going to stop at the grandchildren generation. It's not going to go further than that. And the last grandchild who remains living out of that third generation line, they become the sole owner of the cabin. That's how this family wanted to set up. Everybody was good with it. It was very simple, to be honest. If that's not the mechanism everybody's going to agree to, then that's how it gets more complicated. 50% of the time, we come up with something that completely works for everybody, and it's a great plan. The other 50% of the time, these questions are so tough that it just can't work. You know, again, the sentimental idea of keeping the cabin in the family for generations, the practical side, sometimes it just doesn't play out. And so, you know, then we have to have other tougher conversations about, well, if we can't make this happen for you, then what is this going to look like upon your death? You know, I'm working with one family now where there are 4 children. It's only mom who's left. There are 4 children, and none of the 4 have money to keep the cabin going after mom dies. And mom is really struggling because this is where they grew up for decades. And so the hard part of her knowing that if she leaves it equally to all 4 kids, they're not going to be able to afford to keep it going, and they're probably going to have to sell it. And that's a hard conversation, especially with a place that has so much sentimental value to people, so many memories. Believe me, and I get it. And those are the really tough conversations where just it's the dollars and cents are just not going to align with mom and dad's ultimate goal. Those are the hard ones. Thank you. Well, it's been an absolute pleasure being here tonight and doing this presentation. You know, obviously, as you can tell, this is an area I just absolutely love. And yeah, I get what cabin ownership is about and why it's so important. So I hope that this has helped provide you with a framework to start thinking about what you need to do.